Good morning, everyone. I have 10:32 as the time, so we're going to go ahead and call the meeting to order. All directors are requested to unmute your microphone for roll call. With our agenda posting, we invited members of the public to view a broadcast of the executive committee meeting, which is live at www.youtube.com/State Bar of Texas. We've also provided instructions on how to sign up to speak at today's meeting, and signups were available until 5 p.m. yesterday. Members of the public will speak after agenda item 3 and will remain in the Zoom waiting room until it's their turn to speak. Please note that this meeting will be recorded and that the recording will be available to the public. At this time, I'm going to call on Mr. Apfel for the roll call.
Good morning. Mr. Almanzon.
Present.
Ms. Brooker.
Here.
Mr. Baruch.
Here.
Mr. Cavillo.
Present.
Mr. Carlos Cardenas.
Present.
Ms. Cordova.
Present.
Ms. Varunda Firth.
Present.
Ms. Ferrier.
Present.
Ms. Gibson.
Here.
Again.
Here.
Ms. Harrison.
Here.
Justice Lehrman will be joining us. Mr. McDougall. Ms. Risley.
Here.
Here.
Ms. Scott. Mr. Schrammick.
Here.
Ms. St. Ives.
Here.
Mr. Vargas. Here. Madam President, we have a quorum.
Thank you, Mr. Apfel. At this time, we would like to welcome any members of the public who've signed up to speak. Members of the public will remain in the Zoom waiting room until it's your turn to speak. I will address you to indicate that you may begin, and each individual will be given 3 minutes to speak. And I'll notify you when your time is complete. Do we have any members of the public that have signed up? No, there are no members of the public that have signed up. So we will proceed next with the executive director report from Mr. Apfel.
Thank you, Madam President, and good morning again, everyone. As you know, things have been very busy at the Law Center. Most of the major projects that staff is working on will be addressed in detail by other speakers later in the meeting, so I will keep my report brief. First, some good news. Debbie Garcia started as our new administrative assistant to the board on August 4th. Debbie comes to us from the Jana Corporation, where she served as the administrative assistant for almost 6 years. Debbie is retired from the United States Air Force in 2014 after serving for 20 years in the Air Force. Thank you for your service, Debbie, and we welcome Debbie to our staff. She has hit the ground running and we're thrilled to have her. Also of note, we have a new addition to our legal counsel's office. Some of you may know him. His name is Chris Ritter. Chris is a graduate of Baylor University and the University of Texas School of Law. Since November 2018, he has served as director of the Texas Lawyers Assistance Program, where he's helped countless lawyers dealing with substance use or other mental health issues. In addition to his legal education, Chris has a master's degree in clinical mental health counseling. Before he joined TLAP in 2014, as staff, Chris spent almost 16 years as a civil trial lawyer with significant experience representing and advising governmental entities. He represented 26 counties, several cities, and university employees in lawsuits involving serious injuries, constitutional violations, wrongful termination, whistleblower claims, sovereign immunity, and wrongful death. Chris has substantial experience in providing legal counsel to county judges, sheriffs, commissioners, city officials, and others regarding legal concerns, including tort liability, employment law, discrimination, hostile work environment claims, sexual harassment claims, workers' compensation claims, disability matters, contracts, and insurance coverage. As an assistant civil district attorney, he advised county leaders about legal issues, reviewed contracts, handled administrative hearings, assisted in responding to open records requests, helped with compliance with the Open Meetings Act and election laws, managed discovery and litigation, and coordinated with outside counsel on special cases. He has first chaired more than 30 jury trials, handled appeals, and has prepared complex briefing, pleadings, and other legal documents in state and federal cases. And we are very fortunate to have Chris join our legal team here at the bar. Welcome, Chris. Looking forward to working with you. Brief update on our COVID-19 return to office planning. The Delta variant has interrupted our planning, to say the least, for live events and returning more staff to our facilities. We remain at about 25% occupancy at our facilities with extensive safety protocols in place. CLE sections and other departments that have in-person events in the next several months are continuing to monitor the COVID-19 conditions. Decisions are being made for each event on an individual basis as to whether the event is held in person, virtual, or hybrid. As previously communicated, the State Bar Board meeting on September 24th will be a hybrid meeting with the in-person location in San Antonio. At this time, we are not accepting any meeting room requests here at the Law Center for outside groups. We have an update on our annual reports that are in the works. We're finalizing the new State Bar, CDC, and BOTA annual reports, as well as the volunteer and staff guide. All of those resources will be available to you in board effect in time for the September board meeting. They will also be available to the public on the State Bar website. And that completes my report, Madam President. Thank you.
Thank you, Trey, and thank you to you and the staff that have worked so hard to keep everything moving smoothly during these very difficult times. It's now my pleasure to present my first presidential report. Since June, I've been very busy. I've been attending both local bar association meetings, both virtual and in person. Have been invited to a few in person. I was fortunate enough to visit Texas Tech, Texas A&M, and the Baylor Law School for their orientations, and we'll be visiting St. Mary's tomorrow. Brittany Harris covered SMU, and Laura Gibson covered U of H. So we've done our job getting around the state to talk to entering law students. I'd like to give you a little bit of an update with regard to my presidential initiatives. In the nonprofit world, those of us who advise and served on nonprofit boards know that there are frequently on every agenda something called mission moments, what gives us an opportunity to focus on the work being done by the organization. And so I've asked the staff to work with me to make sure that happens during our board meetings as well. So our September board meeting in San Antonio is going to be dedicated to the work that the State Bar does with regard to veterans, highlighting our Texas Lawyers for Texas Veterans program. I thought it would be appropriate because San Antonio is such a military town. I think they call themselves Military Town USA. And at that meeting, I'll be challenging each one of the directors to participate in a Texas Lawyers for Texas Veterans clinic in their district. Many areas already do it. I'm just invigorating and asking people to restart with regard to those. And particularly in more rural areas of the state where we may need local bars to assist those in the more rural areas of the state. Due to COVID-19, some programs were suspended, and this gives us an opportunity to talk about it. We'll be bringing examples for those new directors who've maybe never seen the clinic in a box, so they'll be present. I'm also, as you all know, one of the my presidential initiatives involves increasing the number of lawyers in the more rural areas of the state. So I'm working with the state bar staff now to find a way that the bar can engage in a meaningful way, to not only encourage lawyers to consider careers in the more rural areas, but to support the ones that are already there. One idea we have is to use our TOJI program to support those who've already made the decision to move into the more rural areas. So I'll invite you to stand by and watch what we come up with. As you know, my Texas Bar Journal columns have started, and I hope you've read my column in the July-August issue where I invited you to take a ride, RIDE, with me as I focus on respect, inclusion, diversity, equity within our bar. A copy of the article is in your meeting materials already, and I'll be expanding on that throughout the year. The newest one on inclusion is already out, and I'm looking forward to your input. With regard to the task forces and work groups, the Presidential Task Force on Diversity, Equity, and Inclusion, as you know, gave us their report at the June meeting, and the board thankfully voted to extend its work throughout December. We've contacted all the task force members to seek their commitment to stay on through the calendar year, and our next task force meeting is scheduled for September 29th. And some of the task force recommendations are related to the Texas Bar Journal. And the Texas Bar Journal Board of Editors Committee has scheduled a meeting on September 29th to form a subcommittee to review the recommendations and consider how they might be implemented. The chair of the committee, the task force, Joe Escobedo, and I have been invited to meet with that group. With regard to the Presidential Task Force on Criminal Court Proceedings, it has met 3 times since our board meeting. They continue to be very busy and active during these COVID times, including a meeting that was held as recently as yesterday afternoon. Early in the summer, when COVID numbers were decreasing, the task force started discussing how criminal courts could continue to use remote proceedings post-pandemic. And by mid-August, though, things had changed significantly, so the discussion has shifted back to COVID protocols in local jurisdictions for things like masks and vaccinations, and what role, if any, the task force should play in making recommendations in this vein. The task force was scheduled to further discuss these issues at their meeting yesterday, and we'll continue to keep you updated with regard to their work. The Public Protection Grievance Review and Client Security Fund Task Force. The task force also issued a report in June, which was referred to the DCAP committee. The DCAP met August 19th and formed subcommittees to review the task force's recommendations. And a little bit later today, Diane St. Ives will provide more detail with regard to that report. The work group on the Texas Opportunity and Justice Program, TOJI, has met and is considering options for the long-term structure of the program. And I will keep you updated on their progress. For those of you who are interested, the original board commitment is projected to last through fiscal year 2023-2024. And then the next couple of items I have for you are actual action items. The first has to do with regard to a redistricting task force. The State Bar Act requires the bar to review apportionment of our bar districts from time to time. And the last time we did this review was in 2011, 2012. So it's time we take another look at our bar districts. In your packet of materials is an outline for the creation of a task force to conduct this study. There's also a proposed roster of members, which consists of all board members. And I've asked President-elect Laura Gibson to chair this group and to lead this important initiative. And she's graciously agreed to serve. The roster reflects geographic diversity of our board districts, as we want the input of all the state. The task force will meet by Zoom mostly throughout this year, which will save on travel costs. They will look at the population of attorney members in each district in comparison to the elected board member positions. I'd like to make a motion to approve the creation of a redistricting task force, including its roster of members.
So moved.
It's coming from a committee, we don't need this, do we need a second? Yes, I need a second, please.
Second. Seconded. Carlos seconded.
So all those in favor, please indicate by saying aye.
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 Is there anyone in opposition? There being no opposition, it passes unanimously. Thank you very much. The second action item is the Building Planning Special Committee. I'd like to discuss with you the creation of a special committee to oversee the management of 1415 Lavaca Building that we recently purchased. The committee will oversee the design and structural plans for remodeling, repairs, and the uses of the building. They will update the board of directors on the progress of the construction. In your materials is a description of the committee and a proposed roster. The committee is made up of the positions of president, president-elect, and chair of the board. It is also composed of members of the facilities and equipment committee, board members, and past board members. I've asked past chair Jerry Alexander to chair this committee, and he has enthusiastically agreed to do so. We anticipate this committee will also be meeting by Zoom and may need to meet in Austin to tour the building and conduct planning meetings. The committee will need to be reconstituted every year by the board. We anticipate this is going to be a multi-year project. I'd like to make a motion to approve the creation of the Building Planning Special Committee, including its roster of members, and I'm looking for a second.
Second.
Second it.
We got a motion and a second. The second was by, when you make a motion or second, I'll ask that you'll say your name for purposes of the record.
David W.
Okay, so we're going to credit that one to David Calvillo. All those in favor of creating the task force, please indicate by saying aye.
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 Is there anyone opposed? There be no opposition, that passes unanimously. And that concludes my report. So at this point in time,
So
minutes. I'm sorry?
minutes.
Oh, okay, so we need a motion to approve the minutes from our last meeting. Does anybody have any corrections or modifications to the minutes? If not, I'm looking for a motion to approve.
Maria Farrier, so moved.
Thank you. Dr. Farrier made a motion. Do we have a second?
Rebecca. Second.
Second from Rebecca Brooker. All those in favor, please indicate by saying aye.
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 Is there any opposition? There being no opposition, that passes unanimously. And at this time, we would like to, we're going to take things out of order. We'd like to go into closed session to meet with our legal counsel. So we'll now, we will now, at 10:50, the State Bar Board of Directors will now recess the open meeting and reconvene in closed session as authorized by Texas Government Code Section 551.071 for the purposes of consulting with legal counsel, including pending or contemplated litigation, including McDonald v. Longley. The site is there. At this time, we'll take a 5-minute recess for our moderator, Jennifer, to put all members of the board, including section representatives and board liaisons, into a breakout room for the closed session. All other individuals, including non-essential staff and other guests, will remain watching the broadcast. We'll notify the public when we are 5 minutes out from returning to open session. Any director attending by Zoom, please turn on your videos so that we can confirm your identity. If you are attending by phone only, please note that we have verified your identity previously. Important, this is very important. Please do not use the chat feature while we are in closed session for open record purposes. At this time, we'll wait for Jennifer to move us all into the closed session. Thank you. Good afternoon. Thank you for everyone's patience while we were in our closed session. We know we have a long afternoon and we'd like to give everyone a little short break to get lunch, but we're going to do two quick things. We're going to, we know Diane St. Ives has a report from the DCAP committee and has a commitment this afternoon. So Diane, if you're ready, we're going to give Santos Vargas, our chairperson, opportunity to do his very brief report, and then we're going to follow with Diane. And then after that, we're going to take maybe a 15-20 minute quick break, just so everybody can grab something quick to eat. And then we'll power through the rest of the afternoon. So oh, I'm so sorry. I should know better than that. Yeah, I started speaking at 12:20 and there was no action taken in closed session. And I'm sorry for that. Blender, but now I'd like to turn the mic over to our chairman, Santos Vargas.
Thank you, Madam President, and good afternoon to the Executive Committee. At the September board meeting, I look forward to introducing to the new directors our communication initiatives that we've set up. Directors are going to be asked to reach out to their local bar associations and offer a CLE presentation on how to maximize your state bar membership and also improve your practice. They'll also have the option of presenting the 30 benefits in 30 short minutes presentation. These can both be done in person or via Zoom. In board effect, there will also be a communications workroom where directors can find their local bar contacts, copies of the PowerPoints, and a variety of available handouts. And Madam President, that completes the report from the chair of the board. Thank you.
Thank you, Chairman Vargas. And with that, we'll move to what item number 10 on our agenda, the Discipline and Client Attorney Assistance Committee report from Diane St. Ives.
Thank you, President. We have a lot of work on our plate and we got off to a great start. And so I will give my general report to you. As President Firth mentioned earlier in June, the board referred the Public Protections, Grievance Review and Client Security Fund Task Force report to the DCAP committee for review. We had our first meeting on August 9th where we determined our process for the review of the report. We divided into of the task force report into 3 subcommittees so that we could look at each of the task force recommendations very carefully. Our first subcommittee meetings were scheduled for the 7th and 8th, and we will report on those meetings at our September board meeting. We tried to set up the committees so that the people that were on each section of the report could individually look at the different areas and had an interest in doing so. I think we have strong committees. We are going to take some time to study the report as we report back to the board on any recommendations we may have. We do plan on getting feedback from the various groups and individuals. We will also look at what other states are doing on some of these topic areas. And if anyone has any suggestions of people that we may need to reach out to, we are also welcome to, would welcome those comments. There is a lot of interest in the report, and we've already had 2 board members that have provided us with helpful research on a couple of the topics, and including case law. It was very well done. It's really saved us some time as we go through this process. We anticipate it's going to be a very long, arduous process that we're looking forward to doing. And as soon as we have reviewed their report, we will report back to, and if we have any recommendations, we will report those back to the board. Now for our action items, our next agenda item, we have 2 rule proposals that our committee reviewed and approved. They were developed and submitted by the Committee on Disciplinary Rules and Referenda as the CDRR, as we call it, through the process identified by the State Bar Act. If the Executive Committee approves these 2 proposals today, we will recommend that the board approves them at the September meeting and hold them for submission to the Supreme Court at a later date as a bundle with other proposed rules. We would like to have a full package of proposals to send to the court at one time, but that won't likely happen this year. The first proposal For consideration is proposed Rule 1.18 of the Texas Disciplinary Rules of Professional Conduct, and that's pertaining to the duties to prospective clients. In your materials, there is an in-depth description of the rule, along with public comments received by the CDRR. The proposed Rule 1.18 is based on the ABA model rule and is used in a majority of the states. We are one of only 5 states that has not yet adopted it. It addresses who constitutes a prospective client, the protection of confidential information, and conflicts of interest. It will provide much needed clarification to lawyers. The committee did have some suggestions to the comments in the rules, but just to clarify, the comments to the rules are approved by the Supreme Court. They are not approved by the bar or the CDRR. Although the comments are initially developed by the CDRR, they can be amended by the court at any time. What is up for approval today is the language in proposed Rule 1.18, but understands that the comments may be changed as we push forward. So on behalf of DCAP committee, I'd like to make a motion that the executive committee approve proposed Rule 1.18 of the Texas Disciplinary Rules of Professional Conduct pertaining to duties to prospective clients.
Thank you, Ms. St. Ives. Coming from a committee, there's no need for a second. Is there any further discussion from the committee members? There being no further discussion, all directors who are in favor, please indicate by saying aye.
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 Are there any opposed? There being no opposition, the motion passes unanimously. At this point in time, we'd like to take about 15 minutes.
Oh, hold on, President, first,
Sorry,
I have one more issue that I need to bring to the executive committee. I apologize. The next item on our agenda is proposed Rule 13.05 of the Texas Rules of Disciplinary Procedure pertaining to the termination of a custodianship for the cessation of practice. The proposal goes in conjunction with Rule 13.04, which was approved in the rules vote this past spring. That rule authorizes a lawyer to voluntarily designate a custodian attorney to assist with the designating attorney cessation of practice and provides a limitation of liability for the custodian attorney. Proposed Rule 13.05 specifically sets out 3 ways to which a custodianship conducted under the proposed Rule 13.04 shall terminate. It also sets out a procedure for disagreements between the appointing attorney and the appointed custodian attorney regarding the appointing attorney's competence. There is a more detailed description of the proposal in your materials. So therefore, on behalf of the DCAP committee, I'd like to make a motion that the executive committee approve proposed Rule 13.05 of the Texas Rules of Disciplinary Procedure pertaining to termination of a custodianship for the cessation of practice.
Thank you, Director St. Ives. Coming from committee, there's no need for a second. I'll call for a vote if there are no further comments. All directors in favor, please indicate by saying aye.
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 Is there anyone opposed? There being no opposition, this motion passes unanimously.
And that does in fact conclude my report, President Byrd.
Thank you. Okay, now we'll take about 15-minute break. We just come back at 12:45. So thank you for your patience. Well, we just take this short 15-minute break. Thank you. Ready? Okay, thank you. Let's go ahead and continue with our meeting. Our next agenda item is a report from the president-elect, Lori Gibson. Ms. Gibson ready to go? Well, we should skip and go to immediate past president Larry McDougall to do his report. We'll come back to Ms. Gibson when she logs on. Larry?
Well, I'll make mine real brief. I started doing live CLE again, and it's pretty much a game changer from doing the video ones. And it really kind of brings you back in talking to the lawyers and hearing what they have to say and what they think. But other than just letting you know that we're starting to do live CLE again, so they've been a success. I have no other report. Thank you, Madam President.
Thank you. Do we have a quorum so that we can do our nominations elections committee report? Yes. Okay, then I will call upon past Chairman Charlie Ginn and past President Larry McDougall for their report.
Charlie, are you up?
I've got it, or you can, Larry. I don't care.
Go ahead. You got the prettier beard.
Darker anyway. Larry and I have got a report today on our nominations and elections committee. Just a couple of quick action items. We began the nomination search in June to identify attorneys who might be interested in interviewing for the president-elect candidates. We published our call in the Bar Journal online. We sent notice to all committees, sections, and local bars. Over the summer, we spoke with a large number of people who initially indicated an interest in being considered for an interview. Over the course of time, we ended up with a list of 6 attorneys who agreed to be interviewed. This year is a small county year for candidates, meaning the candidates can come from the non-metropolitan areas, any county except Behar, Dallas, Harris, Tarrant, and Travis. On August 17th, we conducted in-person interviews at the Texas Law Center. It was a really strong group of nominees, each of whom would do a wonderful job if they had been selected. We were really fortunate this year to see interest from the type of lawyers who are so qualified for the position. I think Larry would agree with me that all the interviews were just fantastic and they did a great job. Every lawyer that indicated they wanted to interview got the opportunity to interview. After much deliberation, the subcommittee voted to select Cindy Tisdale of Granbury and Joe Escobedo of Edinburgh. Their bios and interest letters are included in the executive committee packet under the nominations committee tab. We are very pleased to have both of these dynamic individuals to recommend to the board as candidates for president-elect. They bring a tremendous amount of experience at both past chairs of the board and service to lawyers in the bar, and they're going to run great campaigns. So on behalf of the nominations and elections subcommittee, I'll make a motion that the executive committee approves Cindy Tisdale of Granbury and Joe Escobedo of Edinburgh as the state bar candidates for president-elect for the 2022 election.
And Madam President, as co-chair, can I second it?
Well, we don't need a second coming from that, but we're happy to have it. If there are any questions or any further discussion from the members of the committee, there being no further discussion, all directors who are in favor, please indicate by saying aye.
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 Are there any opposed? There being no opposed, this passes unanimously. Thank you very much for the hard work of that committee. And Mr. Ginn, I think you have another action item.
We do, and the first of which, we have 2, the first of which deals with the term principal place of practice. Larry, you jump in here whenever, just so I don't miss anything here, but the board policy doesn't define what that term means. The staff has had an internal working knowledge of the definition of what it means. We define it as the principal place of practice as the office address given to us by each attorney. If an office address isn't given to us, they use the home address. The database collects the district they're in based on the zip code of that address. It's a simple definition that provides a bright line for us to define what state bar what district a state bar lawyer is in. They've used this definition for decades. So we have drafted a proposed definition for the term principal place of practice. It's in your materials. It's placed in the general definitions section of the board policy. It's a way to memorialize our internal working definition and give lawyers guidance about what the term means. We added an eligibility disqualification for an attorney's principal place of practice for district director elections. Anyone seeking to be a candidate for a director must not have changed their principal place of practice to another district after December 31st of the year of the election. This policy is to prevent an individual from changing addresses at the last minute just for the purposes of running for district director. That proposal would be included as 1.0303C. Larry, do we need to take these up as separate? I guess it's just one motion between the two. Do you want to talk about the electronic signatures, Larry, or do you want me to?
You can, but I just want to let, if people don't know that this became an issue in our last election, and we had a lawyer challenge us, and the problem we had is we didn't have anything really in writing. It was just the way we've always done it. So what we've done is basically codified everything in the way we did it. As Charlie said, we added that deadline date because in this one we had that particular lawyer also, the week before the voting started, changed his principal place of business to his home address so he could qualify. So what we looked at doing, and the purpose of this was to basically prevent what happened by a lawyer, collecting signatures in multiple counties and then realizing that they were two different districts, and wherever he had the most signatures, he declared that to be his primary place of business. And so what we've done is tried to correct that so it doesn't happen again in the future. And I think it's a good change.
And we also sent this definition, not just from this committee, but also to the policy manual committee as well. If we're looking at the electronic signatures, this second proposal deals with the collection of petition signatures for both president-elect and district director candidates. Anyone who wishes to be included on the ballot as a petition candidate for president-elect or district director must submit their petitions to the state bar and be certified as a candidate by March the 1st of the year of the election. The committee discussed the signature process and wanted to clarify what was allowable under last year's rules and under our election rules. Last year, due to the pandemic, the committee and the board approved the use of electronic signatures for the 2021 election cycle to make it easier to obtain signatures. The committee discussed it again this year. They determined that electronic signatures on petitions should be allowed on a permanent basis. This will facilitate candidates in gathering signatures electronically. This means that a lawyer may sign a candidate's petitions form using a program such as Adobe Acrobat, DocuSign, or other software programs to insert an electronic facsimile of their handwritten signature. So we do have a motion on this, Madam President, on both these action items that we can make at your pleasure.
Thank you. Coming from committee, we don't need a second. Are there any questions or any further discussion?
This is Adam Shremick. I have a question. So the policy committee looked at this for informational purposes, and we discussed it. And one of the issues that I raised and that we kind of had a split on, some people thought it was fine, some people kind of agreed with my concern, was why it had to be a facsimile of your written signature, which adds another step in the process. Apparently you can do this with Adobe. You have to fax your signature, take a picture with your iPhone, and then you got to go through all these steps. So I'll be frank, when I do Adobe signatures, I just type in my name and it puts like a little fancy script font in and I stick it into the Adobe. So my only concern is we're adding this requirement that it has to be a facsimile of your actual signature, which is going to make it harder to get electronic signatures and going to be burdensome on the attorneys who just want to sign a form and go on to their day and not have to, jump through a bunch of hoops to make sure it's valid. So that was my only concern with this proposal. I didn't think it should have to be a facsimile of your actual signature. It should be your electronic signature as adopted by you, whatever you do when you sign electronically. Now, I know there's some argument, there's some concern, well, then it could be fraud. I think if we're worried about, the fraud issue, it's really the tail wagging the dog on this. But that's my personal opinion. So I wanted to bring that up because I do think it should not have to be a facsimile.
Sylvia, is Ray with us today? I'm sure he is. I just can't see him in the.
Yes, we'll have Ray come.
Thank you very much. I think it's just an additional option, an additional way to get signatures than from what we had before. Before you could print out like a PDF of the petition form, sign it, scan it, email it back to the candidate who's collecting signatures. It just provides another option, another way. If someone wants to grab the PDF, use their Acrobat, affix a signature on there or DocuSign, it's meant to be easier, actually not harder than before.
I don't disagree with the intent, and I actually think it's a very good option in that we should be making it easier on attorneys to sign these forms when we're inundated by our friends that are running or want to do something. I just don't know why we have to add that additional requirement that it must be a facsimile as opposed to the electronic signature that whatever you use for your electronic signatures. I mean, I file in federal court with an S/ typed atom, so.
Yeah, I think the word, I don't think we're saying it must be. I think we have a couple of words there. I think if I remember correctly, it said something like digital impression, or I'll have to look at it again. But I mean, I think there were several different words that were used of things that you can use for your signature on the PDF form.
So I'm going to support this, just FYI, I'm going to vote in favor of it, but I am going to potentially offer a friendly amendment when we get to the board meeting on this issue, just FYI. So if any other director wants to think about that or, think about which way to go, we all have notice and we can discuss it at the board meeting.
Thank you, Mr.
Madam President, I don't think I made that motion formally as I probably should have. Can I read that language just so we're clear? It's on behalf of the Nominations and Elections Subcommittee, I make a motion to approve amendments to board policy as identified in your materials pertaining to the electronic signatures and the principal place of practice. I'm sorry, Sylvia, my fault.
That's okay. Thank you. Is there any further discussion? There being no further discussion, all those in favor, please indicate by saying aye.
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 Anyone opposed, please indicate by saying nay. There being no opposition, this motion passes unanimously.
And then just the last thing from us, unless Larry has anything, the committee decided to continue to use paper ballots and electronic voting this year as we've done in the past. We've done that for the last 15 years. We believe very strongly that we didn't want to move yet to an all online balloting system because almost a quarter of our voters still use paper ballots, almost 25% use paper ballots. And so we want to continue to make it as easy as possible for our members to vote, which is Adam, I know that's your point as well. And that's well taken. And I don't know that I disagree with the friendly amendment that may come. But we want to thank y'all and I want to thank the committee and Larry for doing such a great job a few weeks ago. Larry, what am I forgetting? What am I leaving out?
Charlie, I think you covered it. I just want to reiterate what Charlie said too, is it was a hard decision this year because we had 6 strong candidates. And when I say strong, I mean really strong candidates. And it was kind of a hard decision. And the voting was split in a sense between the candidates. And so we had to come down to a runoff basically to choose the 2. But it was a great, I was just impressed by the quality of the candidates we had this year and the people interested in serving. And that's just what I wanted to reiterate. It was just a tough decision.
Thank you very much. Is that all?
Yes, ma'am. Thank you so much.
Yeah.
We'll keep moving through the agenda, and the next agenda item is the Policy Manual Subcommittee and a report from Director Adam Schramm.
Great. I'll keep this very short. There's only one thing we need to talk about, which is because we met about the things we talked in closed session and all that. We were at our meeting, but the one voting thing that we needed to talk about with respect to the policy committee has to do with the appellate section's request that we do a change to our rules on when an appellate section can file an amicus brief in support of a particular case. And I'm just going to show you real quick because it's easier to show it, I think, than to try to explain it. This is what our rule currently says. No state bar section may file an amicus curiae brief in a case if any member of the section's counsel represents any party in that case. The concern here is that We have folks at big firms that have multiple offices, and no, this was not driven by me. I didn't even know this was an issue, where they have multiple offices, and so maybe there's an attorney working on a case in another office and you didn't know anything about it. The rule now is you cannot file an amicus, period, no exception, etc. And what the appellate section's actual rules say, their personal rules say, is that if you or your firm or you have any connection to a case on which the appellate section is considering filing an amicus brief, that you cannot participate directly or indirectly in that decision. So you just have to basically disqualify yourself and say, I'm out of it. Y'all discuss it. Y'all decide it. Y'all make a decision. And so that is what the proposed rule change was for. We think it made sense. It was unanimously approved by the committee. We think it makes sense to allow flexibility, and to have one of these hardline black or white rules actually could discourage people from serving on the committee and serving on the council for the appellate section, instead of encouraging people to provide service to the bar. So that's the change. I don't think it requires a vote, but it will be coming for a vote at the board meeting. Any questions or discussion about that?
And you're correct, Director Schrammick, it's not posted for action today, but thank you for that general report. With there no further questions with regard to that matter, we'll move on to item number 11, the Audit and Finance Committee report from Director David Calvillo.
Okay, good afternoon, everybody. The State Bar's financial position continues to be strong and exceeding our budget for the fiscal year. In your packet, you have the financial highlights that in particular describes the budget to actual and the variances, both positive and negative, for the period ending June 30th, 2021. The general fund has a positive variance in both total revenues and expenditures when you compare the budget to actual. And the revenues exceeded budgeted revenues by a little under 75,000, and expenditures were less than budgeted to the tune of 378,000. So overall, our budget had a positive variance of about 451,000. In general, we continue to reap the benefits of holding virtual meetings and postponing events, and that's what resulted in that very positive variance for the budget. We have two audits that we kind of keep an eye on. One is an internal audit and one is an external audit. The external audit is conducted by the accounting firm of Weaver, and Weaver's in the midst of doing their field work as we speak. Everything seems to be on track, and we expect their report for the fiscal year ended June 30th, 2021 to be issued in November, a little bit before Thanksgiving. And we expect the letter that they issue to us regarding their review of internal controls, and as that relates to financial reporting, to be presented to the Audit and Finance Committee in January. The board will be asked to approve the financial statements and the audit report at the January meeting as well. That's the external audit. The internal audit is done by a firm called McConnell and Jones, and they are in the midst of their field work from September through October, with a final report due to management in December. Now, the internal audit, our 3-year audit plan provides that certain areas of the State Bar's budget are reviewed for internal audit issues. And this year it's MCLE, and there are a number of different areas that they're evaluating, including member account maintenance, CLE materials, the website, reporting, compliance, and some internal, so this is another area, the information technology. So the IT area is also subject to an internal audit review this year, and we expect those results to be presented to us by the January meeting as well. So again, we've got the external audit that looks at the financial statements as presented at the end of the fiscal year. And then we have the internal audit that examines things internally. And this year, MCLE and IT are the subject of their review. Two different firms, two different functions, and we'll continue to keep an eye on it for the bar. That's it.
Thank you, Director Calvillo. Does anybody have any questions or comments with regard to this report? If there's no further comment, we'll move on to the next item, which is item 12, Insurance Member Benefits Subcommittee. And I'll call on Director Christina Davis for her report. As Ms. Davis is not on, we'll keep going. We'll go on to item 13. The Administration Committee, and it's my understanding that Director Baruch will be making the report on behalf of the committee. Director Baruch.
Yes, thank you. Reaching or perhaps recognizing the very limits of my ability, I have been deputized to say the words "no report." Thank you.
Thank you very much. Is there a report from the section representatives by Ms. Murphy? Murphy is not on. We'll move on to agenda item number 15. It is from our Supreme Court liaison, Justice Deborah Learman. Justice Learman.
Thank you, Madam Chair. I appreciate it. I want to start off by thanking everyone for all your hard work and doing so much right now between the pandemic and these lawsuits. It's just amazing what all you all have been doing. So thank you very much. That's both to volunteers and staff on behalf of the court. We plan to be returning to the courtroom in September. Our first oral arguments are, let me see, they're going to be the week of September the 13th, and they will be live if everything goes as planned. And then we will have a conference live in the conference rooms after that. We did have in-person conference last week. We issued an emergency order number 41 at that conference, which extended the date for state bar dues to October 31st. They would have been due tomorrow, I think, the end of August. But in light of the Delta variant, we have extended that date to the end of October as we did last year. We had to issue, or we felt we had to issue another emergency order in response to the governor's emergency order dealing with Operation Lone Star that has to do with border security. We issued an order, the purpose of which is to ease the ability for counties and courts to appoint lawyers for indigent people who have been arrested because of border issues and are dealing with issues dealing with their immigration status, et cetera. And so we've issued an order to, for example, just to lighten up on a lot of the requirements. For example, usually a magistrate starts out the process, but then it has to go to another court for that appointment to be made. That step has been taken out and the magistrate can directly make the appointment. That's just one example of the types of things that are being done so that in response to the governor's order. We also amended Rule 57, which now clarifies how to appeal directly to the Supreme Court. The Rule 57 that deals with that really was very confusing, very difficult to determine what to do from the rule because the rule didn't provide any guidance. And so what was happening is that attorneys understandably were calling Blake Hawthorne, our clerk, to simply say, what do you do? And now it makes it clear the procedures are very much like appealing to an intermediate court of appeals. But as you all know, there's statutory, this is very statutorily driven, the ability to do that. We typically do not hear direct appeals, but the process that now has been set out in the rule, at least lawyers now can read the rule and know what they need to do. And again, it's very similar to appealing to an intermediate court of appeals. The legislature this last session has provided for some more direct appeals having to do with ERCOT and some other things, in addition to the normal things that we have having to do with school finance, et cetera. And one more rule that I think you might be interested in is the Rule 4, which has to do with the admission to the bar. We have amended that to allow for persons who have been convicted of a felony within 5 years. And now it used to be that they could not even apply for admission to the bar at all. Now there is a rebuttable presumption that they are not, they do not have sufficient character and fitness to be a member of the bar, but that is a presumption now that can be overcome as opposed to simply not being able to make the application at all. I'll make a more detailed report at our next meeting. I know that we want to get going, and certainly we've had a lot of very, very important things to do today. And again, on behalf of the court, I want to thank everybody for everything that you're doing. Thank you, Madam President. I'm sorry, I called you Madam Chair. I'm sorry, Madam President.
Thank you for that excellent report. We'll now move forward to item number 16, the TYLA update, and I'll call on President Janine Rispoli.
Good afternoon, everybody. I will keep it brief, but still energetic. Hopefully, we have hired a vendor for our civility project. So we're really excited about that. We've got two big civility focuses this year: civility in the classroom and civility for lawyers, and that will be a civility hub similar to the wellness hub. If you haven't looked at the wellness hub on our website, definitely go look at that. It's awesome. Great collaboration with TLAB. We are also working on a wellness retreat in December. Brittany Harrison, our immediate past president, she has been so dedicated to this project since before the pandemic, and we're all really confident it's going to be a wonderful experience. Sylvia and Laura and I have run into each other at law school orientations, and regardless of the COVID or other obstacles, these future lawyers seem very passionate about joining our profession. So that's been really fun to see. Our September board meeting will be the weekend before the State Bar Board meeting. We will be in South Padre Island, which is the backyard of several of our directors, our chair-elect, Judge Lauren Sepulveda, and our past president, Victor Flores. We're coordinating committees so we can record podcasts and videos, so we can get a jump start on all of our content while we are there. Speaking of content, our social media team is doing an amazing job as always. If you don't already, go ahead and follow us on Facebook and Instagram. We have not discussed TikTok yet, and I don't think we will, but that's our social media, and it is wonderful. We finished up a internship program with Dallas area young lawyers, and we're able to meet virtually for socials and working together and mentoring, and that was really great. That was our second year of participating in that with DIYL. Two of our board members were recognized by the ABA-YLD for their work on our board. We're very proud of them. We have an amazing board as always. We're connecting with really wonderful TYLA members, And I know we will make the State Bar proud this year. So thank you.
Thank you, President Driscoll. Does anybody have any questions or any comments for TYLA? There being no others, our next agenda item is for a report from our general counsel. Ross, do you have anything for us?
No, Madam President, nothing to report.
Okay, Ms. Gibson had to leave, but Executive Director Trey Apfel will give the President-elect's report.
Thank you, Madam President. This primarily has to do with the work of the Budget Committee coming up. We'll have the first meeting of the Budget Committee on Thursday, September 16th. The committee will discuss the State Bar's budget process and the timeline for preparation of the fiscal year 2022-2023 budget. The committee will discuss and approve changes to the budgeting process in light of the McDonald opinion, as we've been discussing. Budget planning and projecting has been underway since August. Budget package will be furnished to the State Bar's division and department directors on October 1, with a deadline completion date of October 15. Once budget data is received, the Finance Division will prepare and analyze the budget. The Budget Committee will meet again in December at the Texas Law Center. During this meeting, the committee will finalize a proposed fiscal year 2022-2023 budget for presentation to the Executive Committee and to the board at their respective January 2022 meetings. So that completes the report of President-elect Laura Gibson. Thank you.
Thank you, Mr. Apfel. And that concludes our business today. So with that, I'll entertain a motion to adjourn.
So moved.
We had a motion from Mr. Santos and a second from Mr. Calvillo. So we'll stand adjourned at, what time is it? It's 12. See, I'm out in El Paso, it's only 12. It's 1:20 in Austin. Thank you all very much for your time and attention.